All right, so welcome back. We left off here. So the Supreme Court has the final determination, and through the interpretation of law and constitutional provisions, courts set public policies. Now, there are two competing philosophies, and I believe we touched on this earlier in the class. If not, we'll touch on it now. There is a concept called judicial activism. And that means that judges are more prone to want to set policy from the bench. So the bench where they sit, to strike down laws maybe they feel are unjust, uphold laws that maybe shouldn't be upheld, and this is a judicial philosophy. On the other side of that coin is judicial restraint. A great example of somebody who practiced judicial restraint was the late U.S. Supreme Court Justice Antonin Scalia. He went back and tried to, and this is kind of what it is. The book will give you a concise definition of what you're working with here. He tried to find what was the closest interpretation the framers would have had to a specific law that was in contention at that point in time. Ruth Bader Ginsburg, the late Ruth Bader Ginsburg would have been a great example of a judge who believed in judicial activism, the power of a judge on the bench to set public policies. And on the other side, Antonin Scalia. So there's the difference between judicial activism and judicial restraint. I have explained it. Now we will move on. So Article 6 in the U.S. Constitution establishes the U.S. Constitution as the law of the land. So when I ask on a test or a quiz or something, what is the law of the land? You say the U.S. Constitution. Now, that's different. What is the rule of law? That's the idea that no one, even a president or a king or any grand sort of person, is above the law. So the U.S. Constitution is the supreme law of the land. Judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. So Article 6 is the Supremacy Clause. And the Supremacy Clause is what sets all that up, that the U.S. Constitution is the supreme law of the land. So the National Supremacy Clause, and the way in which it has been applied over the years, establishes federal power over the states. That's not to say the states don't have powers of their own, but you should know that by now with our study of federalism. So who decides? John Jay was the first Chief Justice of the United States Supreme Court, but Chief Justice John Marshall, he wrote, it is emphatically the province and duty of the judicial department to say what the law is. So they interpret the law. They decide what the law means. So judicial review, and I would remember this. I'm trying to get the computer to cooperate so I can highlight this for you. Judicial review, I would remember this again as the authority of the court to declare laws or actions of governmental officials unconstitutional. And this was established in Marbury versus Madison. The Supreme Court granted this power to themselves. This is not in the Constitution. It is not anywhere. The Supreme Court gave this to themselves after deciding Marbury versus Madison. Now, in this class, since it is a state and local class, we're not going to go over Marbury versus Madison. I would encourage you to look at that case on your own. So the authority of the court to declare laws or actions of governmental officials unconstitutional. Yeah, the U.S. Constitution doesn't explicitly mention this. The Federalist Papers, again, I have my students in my 115 class, American National Government, read some of these anyway. They emphasized the importance of judicial review, and it was already being practiced at the state level by this time. So state courts had overturned state laws by 1789, which were in conflict with their state constitutions. So the authority to declare laws or actions of governmental officials unconstitutional. Second time that definition's been brought up. Might be something worthy of being remembered. And that it was established in the U.S. Supreme Court in Marbury versus Madison. So these guys, the Supreme Court justices, and gals, I should say, they are non-elected judges with lifetime tenure at the federal level. At our level, at the state and local level, which is what we're talking about again, they are elected and or appointed judges who tend to serve for a long tenure. On the Supreme Court of the state of Illinois, it's a 10-year term, which is a good long time. So at the federal level, the president appoints judges with the advice and consent of the U.S. Senate. And this is always a big contentious thing every time a Supreme Court nominee is presented. You can just go on YouTube and look up Ketanji Brown Jackson, Justice Ketanji Brown Jackson, her nomination, Brett Kavanaugh and his nomination, Amy Coney Barrett, all these more recent people. The nomination and the confirmation process has now become so politicized for what is supposedly an apolitical branch of government that it is worrying. It is worrying. So, on the state level, and if you notice, I'm comparing the federal level to the state level. The state selection of judges includes election, both partisan and nonpartisan. So you might know you're voting for a Republican judge. A judge might be a Democrat and not have that indicated next to his or her name as well. They could be appointed by the legislature, the governor, or both, or merit-based selection, which may include a combination of appointment and election. And half of the states use some form of merit selection. And I don't know. I honestly don't know which method is the best. That's, I think, just a matter of opinion. And we generally respect and adhere to the rule of law as a people. There have been occasions, though, where governors and legislatures have resisted or delayed implementation of court rulings. And I'm not going to say any more about that because that's part of your assignment this week. So, of course, there are checks and balances on the court, and changing the constitution of the state is a way that a legislature can respond to the policy decisions of the court. It's very hard. Getting an amendment pushed through is meant to be hard. It's meant to be very hard because you've got to prove you've got a lot of support. So that's why we don't see it frequently. They can withhold appropriations, the legislature. So the court gets X amount of money per year. Well, this year they're not going to get it. So given unpopular opinions of the court, the legislature can influence what the court's doing by implementing a particular policy, by withholding adequate funding. So maybe the justices or judges on the state courts might have to cut staff. Maybe they'll have to take a cut in salary, something like that. They can refuse also to confirm nominees. Now, this is a popular move at the federal level. Not Neil Gorsuch, excuse me. I forget what's his name. Merrick Garland, the current Attorney General, was President Obama's third nominee to the Supreme Court, and the Republican-controlled legislature, Senate at the time, because the Senate is who does that, refused to even hear him. So that's a check on the executive there. That can restructure the lower courts. That's within the purview of the legislative branch of the state. They can also impeach or remove judges. It's a rare thing to have happen, to be quite honest. The constitutional power of removal rests with the legislative branch at the federal level and varies with the states. So in Illinois, we created the Judicial Inquiry Board in 1970, and there's an Illinois Courts Commission that addresses judicial misconduct. And the Courts Commission is comprised of one Supreme Court justice, 2 appellate court judges, 2 circuit court judges, and 2 citizens. And the body has the authority to remove from office, suspend without pay, censure, or reprimand any member of the judiciary for willful misconduct in office, failure to perform duties, or for conduct that is prejudicial to the administration of justice, or that brings the judicial office into disrepute. And that could be really whatever the legislature wants it to be or thinks it is. There's really no set definition of what the U.S. Constitution calls it bad behavior, what bad behavior constitutes. So we could have a situation where the General Assembly just simply doesn't like a guy. So they find something.